Hi, my name is Joe Frick with Idaho Divorce Law Firm, and today we're going to be talking about the basics of Idaho divorce law. From filing requirements to timelines, we're going to give you all this information so that you feel a little more informed and a little less overwhelmed during the process. Now, whether you're just starting out or you're in the middle of it, this guide will give you a solid foundation of what to expect and where to go from here. Before we get too far into the divorce process and the law, we need to figure out whether you can or you cannot file for divorce in Idaho. The rules provide that the person filing for divorce here has to be a bona fide resident for at least 6 weeks prior to filing. And what that means is simply that the person that's filing first has lived here for at least 6 weeks and has the intention of living here for the foreseeable future. Now, so long as they're a bona fide resident of the state of Idaho and have been here for at least 6 weeks, that person can file for divorce here in the state. Now, there are some situations that require some more attorney analysis because the facts are going to become pretty complicated pretty quick. Now, those situations are whether you're the spouse and you don't live in Idaho, but you still want to file for divorce. So you're probably going to have to talk to the attorney in your home state and an attorney in Idaho to figure out the correct route, because there's some complications there that can have a big domino effect as far as what to do, especially if there's kids involved, there's property in different states and all that stuff. But for purposes of this video, if you've been a bona fide resident 6 weeks, you can file here. Okay, let's jump into the grounds for the divorce, or what you were going to ask the court to grant the divorce for. Now, in Idaho, there are fault-based divorces and then there are no fault-based divorces. Now, when you're deciding between the two, you're going to have to figure out whether the fault-based divorces are actually going to help your case or get you closer to what you want at the end of the day. Sometimes it's not possible, even if those factors are there, to have an effect on the end outcome. Whether you want to go for the fault-based divorce is a little outside the scope of this video because there's a lot of considerations there, but just know that if you do allege the fault-based divorce, you have to provide the court with the evidence to support your allegations and to show them that what you're telling the court happened actually did happen. So if you want to go for the fault-based divorce or you have something a little more complicated, you're going to want to talk to an attorney so they can sort out which grounds would be better for your case and if the fault-based grounds would actually help you at the end of the day. Okay, now that we know that you can file here and you know which grounds you want to ask the court for, you can get the basics for your petition. You're still going to have to figure out some other stuff. You're going to have to talk to an attorney about that because you still have to put stuff in the petition as far as how you want the property divided, the children's stuff, waste, alimony, all that stuff. So you still got to figure that out. But from here, for purposes of this video, you live here and you can file here, you know what the grounds are. Now from there, after you have the petition completed and ready to file, you got to file it with the county courthouse. And generally speaking, you have to file that wherever the other party resides. For example, if you live in Ada County and they live in Canyon County, you're going to have to file in Canyon County and vice versa. Now, there's really no way of getting around that other than possibly sitting and waiting for the other party to file, if that's what's anticipated. Sometimes they just drag their feet, they're not moving it fast enough, so you have to just go ahead and file it wherever the district court is in your county or the other person's county. Most of the time, judges apply the same rules similarly. It doesn't really matter, in our opinion, as far as which county you file it in, as far as preferential treatment, because Idaho rules of family law are the Idaho rules of family law, and they're getting applied pretty much the same. We can file here, got the grounds, got your petition filed, you file it in the county where the other party resides. If they reside out of state, call an attorney to figure out where you got to file it. With the filing of the petition, you still have to have several other documents like the summons and the family law case information sheet. And depending on the county that you filed in, the court might generate some additional documents that you have to serve on that other party too. So once you have the petition filed, the court will give you those documents and you take all those documents and you give them to the process server and they will serve the other party. Now, the case starts when you file the petition, but the deadline for the other party to respond doesn't start until you actually serve them. So the serving of them is what kicks off the deadlines for them to take action. Now, once they've actually been served, the process server will give you an affidavit of service, file that with the court, and then the timeline goes from there. They have 21 days from the date that they were handed that piece of paper to file a response or a response in a counterclaim. And if they don't, you have the opportunity to file a default judgment against them, which what that means is essentially the court will give you everything that you ask for because the other party chose not to participate. Now, there are some steps that you have to complete during that, but if you're going through those issues, you need to be talking to an attorney because that default issue may be extremely beneficial for you, because as soon as they file that responsive document, your opportunity to file default against them is gone. So when you're filing this petition, talk to an attorney to figure out which county you got to file it and monitor that for the default process. Okay, we've got the petition filed, we've got all those documents put together, and the other party's been served, so that we're within that 21-day time frame that we can't really do anything with that court. However, during that time frame, you can start planning for your temporary orders if you need them. Now, temporary orders are essentially an order from the court that both parties have to comply with and follow during the case while that case is still going on. Now, we use temporary orders for several different things to address issues that are going on that need resolved before the final trial, which could be 6 to 24 months from the date you file, depending on how complex your case is. So we use those to slap a band-aid on those issues to get you by until you get to the trial, to a resolution on all the issues. Now, we use that for a bunch of different things. One, income. We can have the court order the other party to pay you a portion of their income one of 3 different ways. We ask for the court to award it in whatever they deem is the most appropriate. We ask for a division of the community income, we ask for child support, and or temporary spousal maintenance. So what we do is we ask the court to analyze what's going on with the case and figure out what the court thinks is most appropriate and give us one of those things, so that the party that doesn't have as much income or needs that income to support themselves during the case has that money, so they're not going without during that time frame. We use it for asking the court to order one party to move out of the spousal home during the case because there's issues going on, it's detrimental to kids, and a bunch of other stuff. We can do that. We can ask for temporary child custody orders, so we can have an established custody order that both parties have to follow during the case. If you're in need of temporary orders, you need to talk to your attorney to figure out what the best strategy is to get in front of the court, whether it's urgent, whether it's not urgent, and what you actually need to request. But that's typically the next step after you file the petition and you're the petitioner, because you're waiting on the respondent to file a response. And if there are those issues, that's what you would be doing in those 20 days, along with obtaining and gathering your mandatory disclosures to produce to the other side. Okay, after the petition has been filed and the respondent has filed their response or their response and counterclaim, the case could go a bunch of different ways. First, the case could just go away as far as the other party just agreeing with whatever you accepted. Now from there, you would have to file the proposed judgment, get all the signatures, file that with the court, and get it finalized, but that could end very soon after that if the other party agrees on everything. If they don't agree on anything, or if they don't agree on everything but one single issue, the case will still proceed to trial. So you're still going to have to start working on discovery, mandatory disclosures, possibly depositions, subpoenas, experts that you would need for vocational assessments or psychological evaluations or parenting time evaluation. That's what would be going on after the response and counterclaim goes. Most of the time you get most of that stuff figured out within that first 20-day time frame if your attorney isn't super busy or if these issues aren't super urgent. But after the response is when those deadlines start creeping up as far as mandatory disclosures and if any discovery requests get put out. And then shortly after that, you get a scheduling conference with the court that will set the trial date, which will backdate a bunch of deadlines related to discovery, when that has to be done, when depositions have to be done, when your evidence has to be disclosed. So once you get that scheduling order from the court with a trial date, you know what dates you're going to have to comply with to get all the evidence that you need. So right after the response, you need to start coming up with a strategy with your attorney to figure out what you need for trial, how to get it, and how you're going to present that to the court. All right, now that you have your deadlines, your trial date, you know what you need to get, and you know what you need to prepare, let's just talk about kind of a general time frame for most cases. How long your case is going to take is really just going to be driven about how complex it is. So each little issue that you tack on is probably going to involve additional time needed for your attorney or you to gather the evidence that you need to provide to the court. In a basic case, there's not a whole lot to fight over because the court's just going to divide the property 50-50 and give you that judgment. So that's not going to be really complicated because there's not a lot of issues. Moving into, let's say, if 2 parties have their own real property, that's going to add a little extra layer on top of that. So that's going to be a little more complex because you have to obtain evidence regarding the value of the home, who bought it, what funds were purchased, whether it was purchased before or after the marriage, and if it was before the marriage, did it get transmuted to community property during the marriage? There's just a lot of issues when just a house gets involved because you have to figure out what you're going to do with it after the case is over, who's going to get it, who has to pay who back, all that stuff. So with just the house involved, you're going to be adding a little more complexity to the case. It's still probably that 6 to 8 month time frame. There's just going to be a lot more work that you have to do in that time frame. You add kids on top of that, that introduces child support issues, which is people are going to be fighting about what the correct income is for each party to put into the child support calculation. You're going to be talking about child custody issues, which are just a million different issues that come into play. And if the parties don't agree on the custody schedule, that's when it comes extremely complicated, and it could be up to 2 years before you get it resolved, depending on how complex it is and whether you need a parenting time evaluation, a brief focus assessment, a child interview, and then rebuttal experts for that. But when you add children involved, it just adds so much more complexity to the case, because we're talking about the best interests of the children, which is essentially a comprehensive analysis of everything. These cases aren't as simple as just filing some paperwork at the court. You have to actually dig down into these issues to figure out what you want at the end of the day and what evidence you need to get that. So that's kind of a general timeline of how a divorce case would go in Idaho. It could be 6 months, it could be 24 months or longer. It really just depends on how complex your case is and how much you want to fight over each little issue, because that attacks on time every little thing that you have to provide evidence for. So in this video, we didn't dive deep into the specifics as far as child custody, child support, how to divide the assets. We do go over those in different videos. So if I were you, I would subscribe to the YouTube channel just to make sure that you get all that information that you need or want when we put those videos out. Thanks for watching. I hope you found it helpful and educational. But remember, you're not alone in this process. Take care, and if you need help, reach out.